Hello friends, this is Chandrakant from Akulmac Technologies and welcome to Top Brass. And friends, as you know, we are on a journey of understanding human rights, and one of the major human rights is related to fair trial. And to discuss about that, let me invite my friend from Ahmedabad, Advocate Nagesh Sood.
Hello, Chandrakant. How are you?
I'm good, Nagesh. And for the benefit of viewers, let me briefly introduce Nagesh. Nagesh is practicing in High Court Ahmedabad. He's a very senior advocate and also a very well-known human rights activist known across India. So without further ado, let me ask this question about what is fair trial means in India.
CK, right to fair trial is basically a very important human right. Now, if I should say in a very simple language, a trial which is observed by a trial judge without being partial and in an independent manner is a fair trial. So there are various rights which are associated with fair trial, which are there in the international covenants. One is Universal Declaration of Human Rights, wherein Section 10 talks about right to fair trial. Then there is Sixth Amendment to United States Constitution. Then Article 6 of the European Convention of Human Rights has this provision of right to fair trial. Now, right to fair trial is very helpful to explore in numerous declarations. Now, uh, under Article 10 of Universal Declaration of Human Rights says that everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal in the determination of his rights and obligations and of any criminal charge against him. So basically, this right is for everybody in the entire world, which entitles them equality to a fair and public hearing. We call it fair, that it has to be by an independent and impartial tribunal, and there are different principles which the court has to follow while determining or while deciding the rights and obligation of that person and of any criminal charge against him. Suppose a person is criminally charged or accused of a crime, then he has a right to fair trial or fair uh, uh, trial in a court of law. Now, the right to fair trial is also provided under International Covenant on Civil and Political Rights, and it is particularly provided in the provisions of Article 14 and 16 of the Covenant on Civil and Political Rights, which is binding in international law on those states that who are party to it. So India is a party to International Covenant on Civil and Political Rights, and therefore these rights and obligations are binding on us. So what are these rights? Article 14.1 of ICCPR establishes the basic right to a fair trial. Article 14.2 provides for the presumption of innocence. That means anybody who is charged with a crime, it will be presumed that he is innocent. Then Article 14.3 sets out a list of minimum fair trial rights in criminal proceedings. Article 14.5 establishes the right of a convicted person to have a higher court review the conviction or sentence. That means Article 14 provides that he can file an appeal in case he is convicted. by any court of law. And Article 14(7) prohibits double jeopardy, which means that a person cannot be convicted of one crime twice. So these are the basic rights which are provided under the International Covenant. Then we have Geneva Convention. Geneva Conventions, and there are additional protocols in Geneva Conventions that require that if any prisoners of war facing a judicial proceeding has to receive a fair trial. For example, in Article 102 and 108 of uh, the 1949 Third Geneva Convention details the requirement for the fairness of trials against prisoners of war. Other provisions require a fair and regular trial, and the safeguards are provided in that. Now, the right to fair trial is furthermore enshrined in Article 3, 8, 9, and 10 of the American Convention of Human Rights. Now, if we talk of these rights, the minimum right to fair trial includes that the fair trial would be there in civil and criminal proceedings. The right to be heard by a competent, independent, and impartial tribunal. The right to public hearing. That means if a case against a person is being decided, that would be in amongst the people. That means publicly he has to be heard. And the right to be heard within a reasonable time. It should not happen that a person is languishing in jail or there is no trial being conducted against him. So there is a provision that he should be heard in a reasonable trial, and that the court must begin his trial at the earliest. Then the right to counsel. That means he has to be given a right to have his own lawyer, which is another right associated with right to fair trial, and right to interpretation. So the government may limit these right to fair trial or derogate from the fair trial rights only under certain circumstances which are specified in human rights instruments. So this is what the basic which we understand by the right to fair trial. Now, if we talk of India, all criminal trials are based on the principle that the accused is innocent till proved guilty. This is the basic concept we must all understand, that anybody who is charged with a crime is innocent till he is proved guilty in the court of law by a judgment of the court. The presumption of innocence is a cardinal principle of Indian legal system and a basic right of the accused person. The presumption must stand and be the guiding principle right from the moment of suspicion, through investigation, throughout the trial process, and till the delivery of the verdict. So it is very important. You see, what are the stages? A man is suspicious of a police catches him under a suspicion that he must be the accused who has committed the crime. So the guiding principle, the presumption is that is only a suspicion. He is not guilty yet unless the verdict comes of the court. Even through the investigation, he is innocent. And throughout the trial, whether it takes 1 year, 2 years, in concluding the trial, he would be innocent till the time the court holds him guilty of that offense. So there is a criminal procedure which is built around this principle of innocence until proven guilty. and it is designed to protect this right of fair trial. Now, there are different cases which have clarified that the principle of presumption of innocence is entrenched in the Indian Constitution, the Universal Declaration of Human Rights, and Civil and Political Rights Convention, to which India is a member, guarantee fundamental freedom and liberty to an accused. This was held in the case of P.N. Krishnalal versus Government of Kerala by the Honorable Supreme Court. Then, what are the provisions under the law which says that a person is innocent? At no stage of trial is the accused under an obligation to disprove his innocence. So, if I'm being held for a crime or I am an accused, I am under no obligation to disprove. Means I don't have to disprove that I am innocent. It is for the prosecution to prove that I am guilty. And unlike trial in civil action, the burden of proof in a criminal trial would rest on the prosecution and it never gets shifted to the accused. Now, to place the entire burden on the accused to prove his innocence, therefore, is arbitrary, unjust, unfair, and is violative of the Article 21 of the Constitution of India. Now, I take a pause and I would request you to give your understanding, and if there is any question you want to put about anything what we have discussed so far.
So, Nagesh, I'm convinced that there is a procedure for a fair trial, and there are a lot of provisions until you are proven guilty, you are not accused, or you are not a criminal. Like we have all heard in our own lifetime, the terrorist Kassab was given absolutely free trial, and there was a lot of people anger that why we know him, he is a terrorist, but I think the jurisprudence of the legal system had to ensure that there has to be a free trial. So I think we have seen all that. Now let's come back to the current hot case, which is the Sushant Singh Rajput and Riya Chakrabarti. What do you think should happen now? Because the case has been transferred, but in the court of law, the people, by and large, feel that somebody is guilty. I mean, it's running in the mind. But you're saying, as per law, it is not true. So, with the context of the current case, what should happen now? How we should feel? How we should react?
Yes, Chandrakant, as I've said, that everybody has a right to fair trial. So basically, first of all, a criminal machinery comes into action whenever there is a complaint or an FIR is lodged. Now, in the present case also, an FIR is lodged in Bihar, which is now relodged or again lodged by CBI, which is the investigating agency. So, after the lodging of FIR, the criminal machinery starts taking action and would then start investigating as to what is the correct position by collecting evidence on the charges which are leveled, and then put those material before the court of law. So as I said, that until proven guilty, anybody who's charged with a criminal offense is innocent. Now it will be entirely the burden of the investigating agency, which is the prosecution. Prosecution is the state. Now state works through their investigating agency, which is police, or a special investigating agency like CBI. Now, they would investigate the allegations which are made by the father of Sushant Singh or any other revelations which are going to come while investigation, and then the people or the persons would be charged or would be accused of committing that crime. Then the right of the person for having a fair trial is available to anybody, and the person would be considered innocent until he is proven guilty by the court. So this investigation process will be concluded, and the charge sheet would be filed on the basis of whatever evidence is made available. This would be recorded by the police by way of documentary evidence, by way of any other medical evidence, then statements of the people who are witnesses, and then a charge sheet would be filed, which we presented in the court of law. And thereafter, the court would examine, and again the trial would be conducted. And after the court finds that these allegations are proved on the basis of the witnesses' statements as well as the documentary evidence, the person is guilty or is innocent of the charges leveled against him.
So my next observation is that I agree. The process is very fair, and it is basically for the benefit of everyone, because sometimes people don't want to misuse the law. So I fully agree. But the general concern is, if the person is not uh, declared as a convict until it is proven, there is no end to it, because it starts from lower court, then it goes to high court, then it goes to Supreme Court. It basically takes a lifetime. So even though the law has been made with good intentions, but the outcome of that, I'm not saying it's a wrong law, I'm just saying the general perception, because Nagesh, you're also a lawyer. Certain times the cases will take so many years. Now, if you compare our system with any other country, like for example US, which I also presume they also have a concept of free trial, but the decision is taken within 3 to 6 months. So you know that if you are doing something wrong, you will be caught and you will be tried, and it's going to be a fair trial, and you will be convicted or freed in next 3 to 6 months. Whereas in India, we have fair trial, but you don't know how much time it will take.
Well, Chandrakant, so far as uh, giving a person fair trial is concerned, it is very necessary that, as I read out the provisions of international covenants and which are applicable to India, and we have the same procedures adopted as being as adopted by other countries. So the fact is that uh, to begin a trial, there needs to be an investigation. For any case, there has to be an investigation. There has to be uh, some evidence which requires to prove the allegation or charges made by somebody who is either affected, or a case which is registered by a police officer. So then the process starts. Then there is an investigation which takes a longer time. Uh, you know, there is a system. We have a police system. Now, in the present case, also we see that because of the rights available to the person who has been accused in this case of Sushant Singh Rajput, where Ria is an accused, but she had approached the Honorable Supreme Court on account of the filing of an FIR by the Bihar police, lodging of the FIR by Bihar police in at Patna. So this was a right she exercised of going to the Supreme Court that since the cause of action, that is the death, or everything they were living, she was living with Sushant Singh at Mumbai. So everything which is happened, which has happened, is in Mumbai. So Bihar police cannot investigate, and it is within the territorial jurisdiction of Mumbai police that any investigation of any accusation made against her would lie. So this exercising of right culminated into a judgment which came yesterday, and now that CBI was waiting for that judgment to be proactive. Of course, it had already started an investigation, so it took some time to become little proactive and start the investigation. Now, that investigation takes time to come to a conclusion. Yes, the police has evidence, the investigating team has evidence that this person has committed a crime. It has to be brought before the court. Now, with that evidence, the court begins the trial. Now, trial, every document, every evidence will be proved in the court of law, and there would be witnesses who would be called to substantiate the allegations and then cross examine. Then uh, there would be arguments. Finally, the arguments which would be held by the lawyers, and the judgment would be delivered. Now, if you understand the process, this itself takes a longer time. Then the courts are overburdened with cases. Now, if I tell you that in the High Court, there are about 200 cases every day listed before one particular judge. So it is so difficult to decide 200 cases each day, and there are about hundreds of cases which are filed every day. So there is already pendency which the courts have to deal with, and also the number of cases which are being filed is increasing day by day. That's a good sign because people have faith in the judiciary, so they are coming to the court and for justice. So if which means that one judge has to deal with 200 cases in a day. That means there is a lack of strength of judges, right? That means in America, you gave an example that a judgment comes within 2 or 3 months. Now, if we talk about the strength of judges in any court, we are about one judge in amongst 1.5 lakh people. So if you look at the comparison and the strength of judges we have, including the infrastructure, it is very, very minimal, and it is not adequate, and therefore there is more pendency of cases. The decision takes longer. The under trials are languishing in the jails. So it is not about the entire system works like this, and that is how there is a delay in deciding the cases.
So, Nagesh, I think you have explained pretty nicely. So, as a lawyer and as a person who belongs to the fraternity, I think you are saying that, and I also believe what you are saying, that the law is very good. The legal system, legal jurisprudence is very nice and very well. It's designed for the benefit of citizens. The only thing that we need to improve now, or the government has to improve, is to increase the court system, increase the infrastructure which is behind running different courts, and also increase number of judges so that faster trial can take place. But I think the whole thing that has come out from our discussion today is that the legal system is fine-tuned in India for a fair trial. So with this, I would like to end my discussion, and Viewers, if you have any questions, do write to us, and our expert advocate Nagesh Sood will try and respond to you directly. Thank you, Nagesh, for coming to our show.
Thank you very much, CK. Thank you.
See you tomorrow on some other aspect of human rights. Bye-bye.